Hi, I'm Kathy Allen of Audit Conduct. In 2017, the PCAOB cited 5 problem areas for auditor independence. I wrote about these in my winter newsletter and provided some advice on ways in which firms can avoid these independence pitfalls. I'll touch upon each of these 5 areas briefly in this video. First, firms misapplied the SEC's safe harbor provision, which allows a firm to conclude it was independent even though a covered person had a prohibited financial interest in the audit client. The problem was that covered persons were aware of the circumstances causing the impairment, but they were ignorant of the rule, and that certainly does not meet the safe harbor provision. So in light of this, in my newsletter, I mention a couple of tips on ways in which firms can help educate their people and keep them apprised of important independence requirements. Second, insufficient documentation supporting the audit committee's pre-approval of the firm's proposed tax services. Boilerplate descriptions of the services and the proposed fee arrangement just don't cut it, and they don't lead to a good conversation on independence with the audit committee, which is the whole point of the rule. Third, the SEC strictly prohibits the use of indemnification in audit engagement letters, and yet inspectors found some of these in their inspections. Now this, as I said, is a very strict prohibition. There's no liability limiting clauses allowed in audit engagement letters. This differs from the AICPA's rule on independence, which does allow an auditor to be indemnified for knowing misrepresentations by management. I think there's some confusion out there, so in my newsletter I provide some suggestions, some steps that firms can take in order to rectify a situation where they find an inappropriate indemnification clause in an engagement letter. Fourth, prohibited bookkeeping and financial statements prep services. The SEC rules are far-reaching, they've been with us a very long time, and they apply to all audit clients, including affiliates, and they apply to all broker-dealers. The problem here is that they apply to the period covered by the financial statements. And in an IPO or a new audit client situation, if the firm provided prohibited non-audit services during that financial statement period, that's a problem. The way to avoid this pitfall is to actively monitor and proactively apply those SEC restrictions during the financial statement period so that down the road you can keep that audit client that goes public or accept a new audit client. Fifth, communications with audit committees about independence need to take place before appointment and at least annually thereafter, but these are not always happening. Regular, candid dialogue with the audit committee is critically important. Remember, the audit committee is your delegate for the reasonable and informed investor. And we all know how challenging it can be to evaluate the appearance of your independence. And so I would say take advantage of your discussions with the audit committee. They're your sounding board, and make sure you document those conversations. So in summary, education and support from leadership about the importance of independence are key to avoiding these independence pitfalls and ensuring a happy inspection. And lastly, I also wrote in my newsletter about the PCAOB's inspection interests for 2018. So I do hope you'll read my newsletter and send me your comments and questions. And thank you for watching.